Well, we'll start now for the second panel in today's discussions. So welcome back to everyone, and welcome to everyone who's joining us now. So this is the second part of our afternoon's discussions around the main obstacles to the use of alternative instruments to the EAW in cross-border proceedings. And this session will address one of the main obstacles that we identified in our research and that had already been identified in many previous researches, is the over-reliance on detention in respect of non-nationals and non-residents in particular. And so in this session, we'd like to discuss with you and explore ways to overcome such form of discrimination, and discuss as well how procedural safeguards of suspects and accused persons may help to prevent such use of detention. And so I'm delighted to introduce you to your moderator today, Nora Katona, who will be moderating the second panel. Just by way of introduction, Nora works as a researcher at the Ludwig Boltzmann Institute of Fundamental and Human Rights for Austria in the Department Human Dignity and Public Security. Her research focuses on the prevention of torture and ill treatment, the protection of human rights in the criminal justice system, as well as trafficking in human beings. And in the framework of this project, the organization, including Nora, carried out the national research for Austria. So thank you very much. And Nora, over to you.
Thank you very much, Laura, for the introduction, also for having me as a moderator in this panel. A very warm welcome from sunny Vienna. I'm really glad to moderate the second panel with our distinguished panelists. And as mentioned already by Laura, we really aim to explore how these obstacles that you mentioned can be overcome, and also linked to these obstacles that were mentioned first, the over-reliance on pretrial detention and detention in general, but also the overuse of pretrial detention for non-nationals and non-residents, and linked to that also the systematic discrimination that oftentimes come across, how they can be overcome. And in order to do that, I'm very pleased to first introduce Matylda POGORZELSKA from the Fundamental Rights Agency, also from Vienna. So Matylda is a project manager and a legal researcher at the European Union Agency for Fundamental Rights. She used to work previously as an academic teacher, as a case processing lawyer at the European Court of Human Rights, as well as a legal translator. And at the moment at the Fundamental Rights Agency, she's dealing mainly with questions concerning the access to justice and also procedural rights of suspects as well as victims. And the Fundamental Rights Agency has carried out in-depth research on detention in the EU, cross-border transfers and in cross-border proceedings. And linked to that, I would like to introduce and I would like to ask you, Matylda, to please give us an insight into your research findings, especially on the impacts you identified on non-nationals and non-residents, as well as how, in your opinion, EU law addresses discrimination in the use of detention on the grounds of nationality. Thank you.
Thank you so much. Thank you, Nora. Thank you, for Trials, for having us at this webinar. Much appreciated. And indeed, the subject is very important now and always. And in our research, how we research the impact on the non-national, non-resident, we did not research specifically this issue. We didn't ask these questions. However, it popped out during the different studies. It popped out during the research that Nora mentioned on criminal detention and alternatives. And then later on during different studies, which I will mention soon. So in 2016, we concluded the research on criminal detention and alternatives, where we looked at three instruments, cross-border transfer instruments. And I said 2016, so obviously we are now in 21. So this data might be not so fresh anymore. However, some general issues could be identified and occurring. And of course, what we found out then when we asked member states about their use of pretrial detention, their use of alternatives, how they use the transfer instruments. We learned, and of course we confirmed that because it's been researched before, and we knew that pretrial detention is being more frequently used for suspects and accused persons from other EU member states. And there are different reasons for that. First of all, there is this concern that these people, these persons, non-nationals, are more prone to leave the country, obviously. Then in law, there is this condition that in order to be eligible for a bail for not being detained, defendants have to have a permanent residence or address of residence. So this is also an obstacle here. And the different issues. So what we recommend, what was our opinion, that really the close scrutiny is needed, and member states should be aware that this poses risk of discrimination already there. Then when we discussed, or when we studied, we asked a question about social rehabilitation, because as we know, the 3 framework decisions, they partly share this goal, that these instruments seek to promote social rehabilitation. And what we learned from our studies is that many member states approach this concept of social rehabilitation, understand it rather narrowly, focusing just on transferring persons to their home countries, departing from the assumption that social rehabilitation is only possible, or much more possible, only in a home country. So this is something we also flagged and advised member states to also look on different issues, such as established social and family links, and not only the nationality per se. So this is something we found out. Also, right to information. This is something that we are repeating, but I guess we should be repeating that. We know that there are EU instruments, EU directives now on right to information, right to interpretation in criminal proceedings. Also, they are applicable to the European arrest warrant proceedings, and we might say that also to transfer of prisoners framework decision. But what we found out that this right is not fulfilled to its full potential. Namely, non-nationals, people who don't speak the language, or even they do speak the language, but maybe they do not know how to fully navigate in the national systems. They are often less informed. The interpretation and translation services are not always so available, and simply they just do not understand what is at stake and what is the issue during the proceedings. What we learned also, that there are different legal and mental traditions responding to the alternatives to pretrial detention. For some member states, indeed the detention is the default, and then rather national authorities, if the conditions are met, they tend to look at alternatives. For different member states, we'll say that non-custodial measures are the default, and only then, if the non-custodial measure cannot be used for different reasons, the detention is applied. So obviously, for the Fundamental Rights Agency, for us, the departing point should be alternatives to detention. And I was even debating with myself and with my colleagues at some point whether we should be still using this word alternatives to detention, alternatives to pretrial detention, because even this wording suggests that detention is something that we should look at the first place, and only then maybe look for alternatives. So this is just to think through. In 2019, we issued a report, Rights in Practice, Access to a Lawyer and Other Procedural Rights in Criminal and European Arrest Warrant Proceedings. And here for this project, we interviewed lawyers, judges, prosecutors, police officers, and defendants, including persons requested by the European Arrest Warrant from 8 member states. And what we found out, it seems that I will be repeating myself, but these issues are popping out over and over again. So again, right to information and right to understand, so to being fully informed and to be fully able to decide or maybe to give consent to surrender. Our interviewees, they did not understand what it means to be surrendered. They did not fully understand what it means for them, for their future. So this is something also to flag out to member states. Then the huge issue is representation in the issuing member state and in the executing member state. We call it dual representation, dual legal representation. And here we start with all different problems, like linguistic problems, access to interpreter, even access to a lawyer, even the information about this right to appoint a lawyer. So it's like different layers. Even when defendants overcome the first one, if they learn that they have this right to appoint a lawyer, different issues, different obstacles come because they don't have means to do that. Often they don't even know how to find a lawyer. So what they do, they often ask family members if they have anyone to ask. So only here they can find support. And then, even if 2 lawyers are appointed, there is another issue, how these 2 lawyers are going to communicate. Because this is something also that we find out that it's not facilitated by the member states. So again, private contacts, family contacts, there are no channels of communication, and this was flagged to us by lawyers. Then lawyers were referring also to the cases when they had foreign defendants and they were just pre-trial or after arrested because pre-trial or for the European arrest warrant arrested because they did not have an address. So these accounts just confirmed what we learned before from the member states. And now, next month, yes, in March, at the end of March, we are going to publish a report on presumption of innocence. And there, for this study, we asked professionals, lawyers, judges, about the equal application of the presumption of innocence in connection with the pretrial detention as well and European arrest warrant. What we learned is that nationality is a factor that hinders the presumption of innocence a lot. Different people from different member states tend to be perceived more guilty and tend to be arrested more often. And this is what we know from lawyers, from police officers, from different professionals. Ethnic origin is also perceived the same as an obstacle during the proceedings, and we even have accounts of lawyers telling us that, for example, correspondence was blocked because it was written in an obscure foreign language that nobody could understand, nobody made an effort in the prison to understand, and that's why it was just blocked. So this is what we learn in a nutshell. I invite you to read our reports, and maybe there will be more to reflect upon, there will be more to think about. So thank you. And this would be my short presentation. And Nora, you wanted me also to ask about the...
Exactly how, in your view, EU law in principle can address taking the European Charter of Fundamental Rights, but also other EU instruments, how they would be feasible and also in place to really address this discrimination in the use of detention on the grounds of nationality. Would be your assessment in this regard?
Yes, good question, difficult question, I would say. As we know, we have this general non-discrimination clause, right? So any discrimination based on any ground such as, so this is non-exhaustive, and of course, any discrimination based on grounds such as nationality shall be prohibited as well. If we look at Title 3 of the Charter, equality, and especially Articles 20, 21, 23, 24, 25, 26, when you look at Article 47, we have access to justice and to a remedy. And I would say that this is the basis, and that's it. We do not have, as for now, any specific pretrial instrument. So this issue is basically not addressed. We know now that after several judgments of the Court of Justice of the European Union, I'm talking about now Raniozzi case, ML and Dorobantu, we know that there are calls to the Commission to introduce, to develop an instrument about pretrial detention and conditions of detention especially. So there, I imagine it could be a place to address the issue of discrimination of non-nationals. We also know that there are calls for maybe alternatively adopting an instrument listing grounds for non-refusal of European arrest warrant, mainly because this is the decision that is mainly used. We know that, of course, there are other framework decisions, but we of course know that they are not really used. They are, as we say, underused for now. We also advocate for using them to their full potential. So we know that these might be initiatives, legislative initiatives, that there is a room for improvement and there is a room for addressing this issue. What I also wanted to say, and that there is also a noted phenomenon of positive discrimination, especially in the European arrest warrant transfers. When a member state, issuing member state, is asked for assurances that the person requested would be afterwards, after a transfer, held in detention facility that complies with the European standards, especially we're talking here about prohibition of torture and inhuman and degrading treatment. So Article 3 of the European Convention on Human Rights or Article 4 of the Charter. And when a member state issues these assurances, and indeed the transfer is executed, we learn now that very often there are special detention facilities only for these transfer prisoners, meaning these people who came from different countries, they are kept in better conditions. And obviously, from the fundamental human rights point of view, it is not good that there are different sorts of prisons for nationals and people coming from different member states. However, at the same time, it should be noted that it's a right step, because if the better facilities, prison facilities, are being built, it's a direction that we want to go to. So, thank you.
Thank you very much also for your insights and your very recent findings. So thank you so much, and also for your pinpointing different aspects like this positive discrimination aspect, but also the importance about wording. I think this is something very interesting as well, about alternatives, if we phrase them really as alternatives or not. Going a little bit away from the regional level, we would like now to focus a little bit more on the national one, and very concretely on France. And I'm very happy to welcome Constance Ascione from France. She is a Paris-based criminal litigator and also specialized in white-collar crimes and also in very complex transnational criminal cases and litigation as well. She's a member of the International Bar Association, of the European Criminal Bar Association, as well as of the Forum on Defense Extradition Lawyers, and also of the LEAP, which is hosted by Fair Trials Europe. So I'm really glad to have you here, and I would like to pose the first question to you, namely on the French system. So could you please give us an overview how French law takes into account nationality and residence when there is a decision on the necessity of detention, and especially in cross-border settings? So, and maybe even if you could afterwards also elaborate a little bit on the practice complementing the law.
Thank you, Nora. Thank you, everyone, and good afternoon. So I guess our system with respect to detention is quite similar to other EU member states, but I think I will try to be quite practical so that we all have a good view of what's going on in France. So in France, decisions on detention are made based on a number of criteria, which mainly include, first, the need to prevent the suspect from fleeing, and second, the need not to jeopardize investigations, which include the preventing the suspect from colluding with his or her accomplices to give a false version, for instance, preventing the suspect from tampering with evidence, and preventing the suspect from putting pressure on victims or witnesses. And the second, so for these two series of criterion, either the need to prevent the suspect from fleeing or the need to protect investigation, so to speak, being a foreign national, of course, will lead to different treatment with respect to detention. So for the first criterion, it's quite obvious, that of ensuring that the suspect will respond when summoned and will be effectively present in court to attend trial. So as Matylda very rightly pointed out, in most cases when you apply to have bail, you need to provide an address. And for criminal suspects in general, it's always difficult to provide a good and reliable address. And most of the time, it's just not an address. It's that you have to evidence that you have your family with you, that maybe you have a job or an occupation. So obviously, when you have a foreign suspect, someone who's not a French resident, it's going to be much more complicated because you cannot relocate the whole family. Sometimes the suspect don't speak French, so of course they cannot work. They cannot have an occupation in France. So that's the first obstacle. The second obstacle is that even if you have a good project, in most cases, when you have a foreign national or foreign resident, you will still be, your request to be released on bail will still be rejected. And I have a very practical example of this. I'm assisting a young lady who's Dutch. So at first we gave an address in France, which is that of a friend, and it was rejected. Sorry, I'm seeing that I need to speak slower or without the headphones. Okay.
Is it better? Perfect. So yes, so we started with the address of a friend, but it didn't work. And then I worked with an NGO which provides accommodation and social support for people as an alternative to pretrial detention or imprisonment. And we came out with a very good project, I thought, with social support twice a week. She would be in a foyer, she would be given food, clothes. She could undertake specific training in relation to what she used to work in, which is dealing with handicapped children, so very specific. The family had paid for the training, had ordered the textbooks. The NGO said that they were willing to give this lady a computer for her to do her online training, but it still got rejected. And in the very last decision, which is dated 13th of February 2021, so very recent, the judge says, so yes, Mrs. X provides a certificate from this NGO. She's saying that she will undertake this training course, but, and here I quote, she's nonetheless of Dutch nationality and nothing guarantees that she will not go back home. And that's literally what the judge wrote. And so there's a very strong presumption, and I would say one which is impossible to rebut, that foreigners will go back to their country and not come back to face trial should they be released on bail. So this very strong presumption is really the key obstacle to foreign residents or foreign nationals being released on bail. And even the second series of criterion I mentioned, so investigations and the need to protect investigations, are also something where being a foreign national will be taken into account, because in most cross-border proceedings, and when the suspect is not a French national or a French resident, you will need to have investigations carried out abroad. They take a lot of time, and the lawyer and the suspect have no visibility on what's going on. So in France, for instance, the judges send a commission rogatoire internationale, which is a formal request by the French authority to the Dutch authorities, for instance, to investigate a case. And you hear nothing from them until they respond with a formal response to this initial inquiry. So in the case of my Dutch lady, the request was sent in June 2020, so 8 months ago, and we heard nothing from the Dutch authorities, and nothing is going on in France because there's nothing to investigate in France. But still, the judge would say, but investigations are going on. And you as a lawyer, cannot rebut that. You cannot contradict that because you have no information. So it is yet another obstacle for foreign national or residents from being released on bail, because every time the judges will say, but investigations are going on. And so because they're taking forever, well, the person just has to stay in prison forever. So this is sadly the two ways in which in France, definitely being a foreign national or a foreign resident will lead to discrimination with respect to pretrial detention.
Thank you very much for sharing also this experience and this concrete case with us. So you have already mentioned that the possibilities of lawyers are limited, but do you see any possibility and effective possibility how lawyers can challenge detention in cross-border cases, mainly based on national law or based on EU law? Do you see any possibilities?
So it's not like me to be very pessimistic, but the short answer to that is EU law is not being effective for the time being in fighting all these obstacles that we identify. So in France, judges are quite reluctant to use EU law, of course, partly because they are not very familiar with it, and partly because they do not trust it, really. I feel that detention is in the area where judges, at least French judges, remain very old school, if I may put it that way, and they do not really welcome what they see as creativity. And by talking to friends who are judges, I also noticed how huge a responsibility it is for them, detention. Everything in relation to detention for judges is very heavy, and I think as lawyers we have to acknowledge that. Otherwise we're not being fair and we're not being good lawyers. But we have had a number of instances in France where suspects would be released on bail, and then they would go on to commit a horrid crime, and then the judge would be, criticized, and public opinion and the media would go on about our lenient judges, our red judges, and so for them it's a huge responsibility. Most of the time, the judge making the decision is alone. So it's something that's really complicated for them. So it's also why it's an area where it's difficult for them to be courageous or creative, and so to maybe accept what EU law could offer in that respect. So I have nonetheless tried to ask for EU supervision orders, and in my experience, so either the judge does not address the point when issuing the decision, it's just so beyond the point, or the judge merely states that it's not efficient because the person is going to go back to her or his own country and then not come back to attend trial. So the supervision order, it's, in my experience, it's not working. And I think in France we had two positive decisions for the time being. So not very much. And European investigation order, I'm just thinking about all this just for theoretical purpose, but really it's not working at this point. So when the judge has the suspect detained, of course he's not going to release the suspect to go back to his or her own country and then ask for the person to be interviewed. So when detention is there, it's already too late, I would say. So unfortunately, from my experience, EU law has not proven effective in challenging detention in France, and I think it's a pity because it's a EU-wide problem. So addressing it at an EU level would be really relevant and efficient.
Thank you very much. And then I have a last question concerning also linked to the European law, but also more on concerning standards. There was a ruling from the European Court of Human Rights in 2020 concerning French prison conditions. And in your experience, and also since the developments since then, have you, how would you consider, are regional standards suitable, and could they help to challenge the overuse of detention? Is this a standard that could be also useful for lawyers to argue?
Sure. Yes, so now I'm going to be optimistic. So I don't know if you're all familiar with this ECHR ruling, but it's a ruling that was rendered by the ECHR in January last year. It's called the JMB case. So basically the ECHR found that France violated Article 3 of the Convention because of prison conditions in some prison facilities and general overcrowding. And 2, that France also violated Article 6 of the Convention because of the lack of effective judicial remedy for prisoners suffering from inhuman and degrading prison conditions. And so the ECHR urged France to reduce prison overcrowding and improve prison conditions, and to provide an effective judicial remedy for prisoners suffering from inhuman and degrading treatment as a result of prison conditions. So it is a very important ruling. In practice, it has not yet led to major changes because we are still waiting for a law to be voted on this issue of the legal remedy. And because the response that France is giving, and even when asked to provide information with that respect by foreign authorities in EAW proceedings, for instance, France is saying that they are building more prisons. And so that's the response, basically. But with that being said, it is still a major ruling that shows that European standards are definitely indispensable, as we would say in French. We really need them. We cannot dispense with them. So I recently attended 2 conferences, one organized by Fair Trials with someone from the OIP, which is the main NGO which led the way to that particular decision, and another conference with Patrice Spinozzi, who's the lawyer who advocated the case, the GMB case, before our French Supreme Court and before the ECHR. And very interestingly, so both the OIP and Patrice Spinozzi pointed out that this fight and this very good result of this ruling by the ECHR was a result of years and years of strategic litigation before all sorts of national jurisdictions, administrative courts, criminal courts, lower courts, Supreme Courts. And although there were some minor improvements, there was no major change, and there was no major decision, such as one that was rendered by the ECHR. And Patrice Spinozzi said that this should not come as a surprise because there was no public or political support for change in that area, in the area of prisons. And in France, like in some other countries, there's a tendency to think that general opinion does not really care about prison conditions, and in a way that prisoners are only getting what they deserved. So improving prison conditions is not going to help you get votes or very few. So it's not a good political topic to address. And although I feel this is something of a caricature by Patrice Spinozzi, I think he has a point, because there are indeed questions and domains where it is difficult to get public support and to get MPs and governments to do something about it. And of course, judges in France are not elected. So in theory, they could depart from public opinion, but they're also in charge of applying the law. And so if the law does not provide them with instruments to, for instance, put an end to overuse of pretrial detention, there's nothing much they can do. So I think this is why, and the ruling by the ECHR really shows that they can be really drivers of change. It doesn't mean that countries do not need to do their own work, but they can be really drivers of change. And we saw it, for instance, with the roadmap directives, which led to changes for which lawyers and human rights activists in many countries had been campaigning for years, like, for instance, lawyers in police station during police custody. But with the roadmap directive, it was made possible. So definitely there's hope that regional standards can help prevent this overuse and misuse of pretrial detention.
Thank you so much for this very honest and also very open and also optimistic, partly optimistic statements. Thank you so much also for giving us a little bit of insight in your practical work. Moving away from the practical to a more academic area, I would like to give the word to Stefano Montaldo. He holds a PhD in EU law and is currently an associate professor of EU law at the University of Turin. His main fields of research are judicial cooperation in the criminal matters in the EU, also migration law and EU institutional law. And he was also currently carrying out 2 EU research projects on transfer of prisoners, on the European Supervision Order, and on the Framework Decision 947. And he's also a lawyer, so he's also part of the Bar Association in Italy. So he also shares, besides the academic background, also a practical one. So I'm really happy and glad to give the word to you, Stefano. And I would like and invite you to a little bit explain, based on your extensive research, how do you what do you see as main arguments for the failure of alternatives to address the overuse of pretrial detention in cross-border settings?
Thank you, Nora, and good afternoon, everybody. Let me please say, first of all, that I'm very happy and honored to be here with you all this afternoon, and special thanks to Laura for inviting me. This is a question which I have dwelt on quite a lot over the last 2 years. Let me just provide you the framework of my answer, because we developed a research project named Trust in Action, the University of Turin, involving Italy, Spain, and Romania, and especially in Italy, also the Italian Ministry of Justice was partner to the project. And we focus mainly on Framework Decision 947 and European Supervision Order. So that's why alternatives, generally speaking, are somehow in my discourse in these years. When trying to tackle this question, I have tried to classify possible factors into main categories, just as a way of trying to, put the possibly relevant elements in some kind of an order. And these 2 categories are European related factors and national related factors. We will see that I think that most of, when it comes to these 2 framework decisions, and especially framework decision on the European Supervision Order, the national factors, I think, are pretty much intense as far as their effects and consequences in daily practice are concerned. Most of European factors have to do with how the framework decision, I would say the framework decisions issue have been designed. So when it comes to the European Supervision Order, one of the most challenging aspects, especially, I'm referring especially to a very recent body of case law in Italy by lower courts, refers to the very wide discretion on the part of the Public Prosecution Office and the public prosecutors to decide on whether to go for a European Supervision Order or not. We have some very recent cases dating back to November and December 2020, Northern Italy, where even in cases where the defendant really wanted to involve this kind of mechanism, the public prosecutor, because of public order concerns and due course of justice and so on and so forth, and basically mistrusting the authorities of the fellow member state, decided not to issue a European supervision order, and this was eventually, I mean, the outcome of the procedure. And the defendant had very limited room for challenging this kind of discretionary decision because of, I mean, very factual circumstances of those cases, but also because of the difficulties in dealing with the, I mean, the daily relationship between defendant and public prosecutor. Then in our experience, we detected some issues concerning the incentives on the part of the judicial authorities involved as to the issuing of a European supervision order. That is, I mean, a very, very practical argument. Namely, we developed some, we had some interviews, and some public prosecutors plainly and clearly told us, well, for us, European arrest warrants are very interesting because with one step, namely surrender, we get rid of a person, let's say. And of course, I'm using a little bit of a simplistic terminology. A European supervision order requires us some sort of a sequence of steps, because of course we need to take into account a continuous interrelationship between us and our fellow authorities in the other member state involved. And this is extremely time consuming for us, and we had a couple of public prosecutors telling us that those very few cases they had turned up in nothing because there was a violation of the alternative measure, and the communication between the two authorities simply failed, and nothing happened in terms of follow-up to this kind of situation. So this is, I mean, in terms of how the mechanism is designed, which is basically, I mean, very difficult to cope with in general terms, as in a way or another, the judicial mechanism, which is basically, as someone says, mutual recognition is also a way of coordinating horizontally judicial authorities, has to work. Then I would say that the most worrying situation refers to national factors. And this is so because we detected several institutional and operational flaws in this area. And we did so by basically, our research was conducted from a twofold perspective. On the one hand, we made some research in the field. We had the possibility, especially in Italy, to have access to the files stored in the Italian Ministry of Justice, which is the central authority for most of judicial cooperation procedures, and to have a look at the case files, basically. And also we, as I told you, we developed some interviews and some 3 workshops with selected experts from the national judicial authorities. And we detected some interesting issues, namely, first of all, the tendency on the part of the national legislatures, coupled by the practice of the judicial authorities to restrict the scope of the personal scope of application of the European supervision order. So basically, the possibility for the member states to apply this kind of procedure also to non-residents has been quite limited by the member states at the time of implementation, and it looks like the case law at the national level has not yet challenged these decisions. So, for instance, in Spain, we have quite strict limitation to non-residents. but they have no cases, so these limitations are still there, even though even the members of the judiciary told us, well, maybe they are not so reasonable in terms of maximizing the application of this instrument and of alternatives to pretrial detention, more broadly speaking. We also detected another very practical and institutional concern, namely turnover. This can sound a little bit strange, but this is very problematic, especially in those member states where the management of judicial cooperation procedures is deterritorialized at the local level. So, for instance, in Spain, we have basically two offices taking care of judicial cooperation issues, especially when it comes to 947 and 829. Whereas in Romania, Spain, and most of other member states, the competence is decentralized at the district level. And when it comes to rare procedures, such as the European Supervision Order, this limited application is further exacerbated by the fact that you have a person who is in charge of that office for 1 year, and then on a regular basis, she is replaced by someone else who has really no idea about what's going on, especially with this kind of procedures. I can tell you, and I mean, somehow as a joke, that sometimes I receive phone calls even from our national authorities telling, oh, what should I have to do with this? Well, there is someone who maybe is better placed than me to cope with this kind of situations. More technically speaking, we also have difficulties. We detected some difficulties as far as adaptations are concerned. National laws of implementation are, in principle, from a formal point of view, very compliant with the framework decision. This applies to the European Supervision Order, but also to the probation framework decision 9447. But when you dig up and try to see whether the national categories are in line with the rationale of the framework decision and also are somehow comparable, adaptable with other legal orders, then we see some interesting cases of difficulties. Just to provide you with an example. In Romania, there are some recent rules on postponement of execution of enforcement of a penalty, falling under the scope of application of 947, on which the national legislature is trying to and also the judiciary is trying to push a lot in terms of trying to minimize detention following sentence. And however, this kind of instrument is basically absent both in Italy and in Spain. And when it comes to European Supervision Order, for instance, Italy has some misses some measures that are available, for instance, in Romania and Spain, such as an obligation not to drive a vehicle, which in Italy is not an alternative, a judicial measure, rather an administrative one, or other prohibitions, such as prohibition to conclude contracts with public authorities or to conclude to serve in apical posts on companies or in public administration. So when you dig up, you really see that legal fragmentation is still nowadays a problem, and also the lack of flexibility on the part of some judicial authorities exacerbates this problem.
Thank you very much for this great insight and also overview about the identified challenges that you have come across in your research. And I would then have a final question to you. And in your opinion and also in your experience, is there a need to adopt shared standards as pretrial detention on a European level, based on your research and on your findings?
This is something that practitioners and scholars have been talking about over the last 10 years, basically. And quite interestingly, and very recently, even an Advocate General at the European Court of Justice pleaded for this legislative step at the EU level, namely Advocate General Pitruzzella, quite soon after his appointment at the European Court of Justice, interestingly enough, in the DK case of late 2019. The point is that from an institutional point of view, on the one hand, the European Parliament has continuously and repeatedly tried to push the Commission to go for this kind of initiative. But on the other hand, the Council and the individual member states have quite clearly showed some criticism from this point of view. In the end, I do think that harmonization, even though minimum could be beneficial, but in an indirect way, so to say. Of course, in case harmonized rules on pretrial detention would be adopted, they would be extremely minimum. That it could be the only way to let the states accept this kind of initiative. So I would say that, bearing in mind some of the existing legislations at the national level, the primary consequence would not be legislative change, rather the possibility to facilitate somehow litigation, and the possibility to facilitate change throughout litigation. I do see that this is something that I think we have experienced also in other areas of judicial cooperation in criminal matters, both at the European Union and at the national level. Think about the European arrest warrant. For instance, in Italy, the European arrest warrant was not available for non-nationals, and it was just because of litigation that we eventually managed to change this situation. We have now another extremely interesting constitutional complaint pending concerning the possibility to trigger paragraph 6 of number 6 of the European arrest warrant referring decision, also for long-term residents and more broadly speaking, third country national, which is something the national legislation doesn't provide for. And this is all especially due to the proactiveness of lawyers and of some judicial authorities. So even though I am an EU lawyer, and EU lawyers are quite often have a positivistic approach to law and really love codes, written legislation, and so on and so forth, I really do think that minimum harmonization would be beneficial from this ultimate point of view.
Thank you very much. Thank you. Also, I think it was very interesting to hear also your final points on this facilitate litigation. And I have just seen that there were questions to the panelists. So I would like to read them out so also the others can hear the questions, because I think it's not visible to everyone. It was to Constance. And it was 2 questions concerning both your presentation. And the first one is if the request was MLA or a request or IOO, European Investigation Order. This is the first question, and maybe I can also read out the second one, because this is also concerning your presentation. Thank you for this insightful analysis about the presumption of detention, rather detention bias against non-nationals. Isn't it the case that the lack of information, an obstacle for the application of the European supervision order, is due to the fact that the probation services in the executing country, in your case the Netherlands, are not involved? They might provide useful information, but the framework decision did not design a direct role for them. Framework Decision 829 is based entirely on the blueprint of a judge-to-judge dialogue.
Shall I answer both questions, Nora? Yep. Okay. So I have to admit that I don't understand Fabrizio's question. Was the request MLA? I'm not familiar with the acronym, my attempted request was a request for a European supervision order, so for the person to be released on bail and go back to the Netherlands. I don't know if that's clear, Fabrizio. If you want to elaborate, I'm happy to further discuss this. Okay, perfect. And with respect to the second question, it's a very interesting point. In the case of France, when we ask for...
Sorry,
yes?
if I may ask for your microphone, sorry.
Is it still not really working?
Not working well, no. Thank you.
I thought it would make things easier, but no. Okay, thank you, Nora. So yes, for the second question, so when we ask for a client to be released on bail, we have to provide evidence that it's going to be reliable. So probation services do not really come into account or do not really play a role. But I think it's a very interesting point, because maybe in the case of transnational cases, it would be a way to reassure judges if they could have a direct correspondence in the other country to ask for more information, and maybe for that specific service to supervise even more closely the supervision order, if it was to be ordered. So I think it's a very good point. In France, it's not at the moment, it's not something that could be really applicable, but I think it's really interesting. I don't know if that answers the question. I'm happy to further discuss.
Thank you very much. I would also like to ask if there are any other questions. So if so, please write it into either to the chat or the Q&A section. And I would also like to ask the panelists if they would like to comment or to have any questions to each other. And if so, please let me know.
I'm sorry, can I just step in with a little bit of advertising? No, I forgot to share, and I'm doing so on the chat, a collective effort which is still open for additional contributions. So it's also an invitation for those of you who are willing to contribute. This is a special section of the online open access review European papers on pretrial detention and alternatives. It is a way to celebrate the 10th anniversary of the European supervision order somehow. And this is one thing that I coordinated during that project I was referring to, and a couple of attendees to this seminar contributed to it.
Thank you very much for sharing it. Are there any other questions, remarks? If not, then I would like to thank you all a lot, also for sharing your experiences and your insights, and also your results of your research you have conducted over the last years. So thank you very much, and I would like to hand over to Laura.
Yes, thank you very much, everyone. And to conclude, we're delighted to welcome Joana Gomes Ferreira. Joana is a public prosecutor and one of the leading experts in judicial cooperation in criminal matters in Portugal and beyond. She has been the head of the General Attorney's Office, the International Cooperation Department, for many years and has a lot of experience in cross-border judicial cooperation. Joana is also a member and has chaired the Council of Europe Committee of Experts on the Operation of European Conventions on Cooperation in Criminal Matters. And so we're really honored to welcome Joana to draw some concluding remarks, some key takeaways from today's discussion. Thank you very much, Joana. If you unmute.
Okay, good afternoon all. Thank you very much to have me and me to have you in my kitchen, but this is our days, isn't it? I'm very glad and very honored by the kind invitation from Fair Trials. The idea in the beginning was to provide some information on the priorities of the Portuguese presidency, and I was not competent to do so. I'm a prosecutor. My intervention in the Portuguese presidency will be at European Judicial Network, which is a group of experts, and therefore I don't have much information on the big insights of the presidency. I decided not to come with written things or written remarks, to be fully open to hear you. And I'm very glad and wish to greet the Fair Trials organization for providing me with this different type of interventions. And I'll try not to be too erratic. I will try to follow a path, but forgive me, it's a lot of information, a lot of ideas, and I maybe forget something that I would afterwards regret to have forgotten it. First, I would like to underline the second panel, especially Matylda and Constance, and I'm not mentioning Stefano because I will mention him afterwards, for having underlined to us a general state that in the case of France is somehow verified, of discrimination towards suspects that don't have the nationality of the state where the criminal procedure is pending. The little big things that Matylda mentioned, like for instance, interpretation, which is something that is absolutely crucial. How can you conceive to have a judicial act taking place and you're the aim of that at that measure, and you're not really understanding what's going on. And of course, lawyer support is a major point to be underlined here. Also, Matylda was very straight to the point of something that sometimes makes me think, which is the positive discrimination that has been created by the assurances to be given by the executing state, for instance, or the issuing state on placing someone in a specific prison facilities. We, in Portugal, we had a particular problem with one of our prisons. And when I see the head of our prison services assuring that that person will not stay in that facility for more than X days, and wonder what is the fate of those who are not being brought to Portugal through a EAW, but are already there. So, and on the intervention of Constance, I would like to underline something that is a constant state of play for those who work in international cooperation. I should have started by that. I started a career of prosecutor many years ago, when I had enough experiences outside being involved in international cooperation. And then for the last 20 years, I've been involved in international cooperation. And so I've seen lots of things. I came from extradition to the European arrest warrant. I came from the MLA, which is basically Commission Rogatoire, into European investigation order. I've seen all these framework decisions and directives flourishing, starting from a point that was assumed to be there, which was mutual trust. And it's not exactly like that. Those of us that work with international instruments are very much aware that mutual trust is not a starting point. It's something that you can achieve later on. But for instance, the difference of systems. For instance, the way framework decisions or international instruments are transposed with little adaptations to the national realities at the end, bring judicial authorities or public prosecutors that are, in fact, when they act, international, European prosecutors, to a moment where, after all, the law is not exactly the same to all of them. And so, coming back to the first panel, it was for me very, very easy to follow the stones that were placed in the path for me to follow. First, Lucas talked about something that is quite important, which is prosecutors, especially because we are talking about the investigation phase, and EAWs for criminal proceedings have their own strategy, and we cannot ignore them, especially when we are talking about very serious crimes. We have to understand that those people that have the investigation in hands, also because that they are pushed to it by society itself, they want to go as fast as possible. And in that will to go fast, the European arrest warrant was very tempting. I remember that at that time, I don't know if Vania recalls him, someone very well known in Portugal talking about the EAW, compared it to a Ferrari. If you have a Ferrari, Italian, and you place that Ferrari that is in a very good mechanical condition in a very straight road, very well conserved, the Ferrari goes fast. And there is nothing more tempting for a prosecutor than to have very fast results. And so the EAW that started as a major actor tool to achieve very good results found itself to be used, and me at the central authority are very much a witness of that, to be abused, what I can call abused, which is to use EAWs to things that you can very much and very easily obtain by sending an MLA, sending an EIO. Except that the EAW, with the EAW, you could have the suspect in front of you in 2 weeks. And if you send the commission rogatoire, it will take like 6 months. So it was quite tempting. And in that line, the European investigation order, by using 2 of the tools that the EAW brought, which are time limits and a form, in fact, changed the equality of mutual legal assistance, and in that point somehow controlled a little bit that abuse of the European arrest warrant. And then James talked about national traditions, and that's also very something that you have to have in mind. For instance, he said that Irish judges tend to resist or not to impose provisional arrest, while many other states' judicial authorities have a very different approach to that, and much easily will use measures of provisional arrest, especially if they are related with foreign suspects. Also, another thing that he mentioned here, and I underlined it, was the problem of proportionality that has been raised in the European arrest warrant evaluation reports, and that now is directly mentioned in the TCA agreement with the UK authorities. And so how will an Irish judge, he mentioned, react to the fact that if he uses the TCA, he has the proportionality issue as a cause for refusing, but if you go to the European arrest warrant, you don't have that. So this creates a state of confusion with this lack of harmonization, many fields of cooperation that a national judge has to face. Fabrizia mentioned another issue that I was very, very much interested in, which is the issue of fundamental rights and how is it addressed in different EU instruments. I think Matylda was there too, in September in Germany. There was a major seminar on, you were there, yes, a major seminar on the European arrest warrant. And my workshop, the one I had to deal with, had to address the issue of fundamental rights and the European arrest warrant execution. And one of the things that the main speaker, Frank Zimmermann, said was that this fundamental rights issue as a cause for refusal is very differently addressed in, for instance, the EIO directive and the European arrest warrant decision. So at the end, it seems that it's going to be easier to refuse an European investigation than to refuse a European arrest warrant. And all this, I've been mentioning many instruments to come to a point that Stefano, and I said that I would come to Stefano, together with something I heard from Vanya, interested me more. This prosecutor and this judge you are talking about has already some training in international cooperation, but also due to the fact that, and that's my personal opinion, that the Council of Europe conventions on extradition and MLA were very much used. So there is a long tradition of requesting for the surrender / extradition of persons, a long tradition of sending requests to gain evidence. The authorities are familiar with that. These ones, the European Supervision Order, for instance, or the Nora 947 on conditionally release procedures. The first one is new. The second one is not new. It was, we had already a convention of the Council of Europe since '64, but it was not a very well known. So from the part of the those who are going to apply these instruments, there is a shy state of acknowledgement. And I'm surprised when Stefano mentioned that in his project of what he talked about, and I heard him also in the PONT final conference, when he talked with prosecutors that said, well, the European arrest warrant is easy. The person is there or is here. And if I use the EAW, that will imply a lot of, contacts afterward, contacts to follow. And I was surprised because I bet that if that project would come to Portugal, most of my prosecutors would not even be aware of the European Supervision Order. So not to mention that major problem. So to this, I came to a very, simple conclusion that there should be a raise of awareness. And this raise of awareness from my side, it's something that Vanya mentioned, and I liked also very much what she said. Not to mention the rest, but me and Vanya, we've been hearing each other for a long time now. So she mentioned holistic approach. And I like that. I liked very much this holistic approach issue. Everybody is bringing training. We have the European Judicial Network, European Judicial Training Network. We have the ERA. There are lots of projects and seminars. And at the end, you will find a judge or a prosecutor very much alone. Constance mentioned that, and it was very, very much in the point. Judges and prosecutors at the end are alone. Sometimes, like Stefano said, it's helpful if you have a lawyer that is already enlightened about that and can somehow push the procedure towards the application of a good solution. I remember that last year, I was in Denmark for the evaluation, the 9th round of evaluations, where we were exactly evaluating the application of ESO 947 and the combination of EAW and 909. And I remember that when we addressed the issue of 947 or the ESO, the first reaction from the Danes were, but lawyers should mention that, and they don't. So like Stefano said, lawyers have a major role here, which is to open the minds of judges and prosecutors that, like someone mentioned too, I think it was Stefano, don't even have major national case law addressing these issues, to the reality, to the existence of this possible complementarity between the several instruments across Europe. Personally, it gave me a very good idea. I'm from the central authority in Portugal. I started a very, well, simple thing that I like much. I start doing, together with an expert on human rights and a prosecutor, a little publication. We finished just the first one. It's not out yet. It is called Human Rights and International Cooperation. And the aim, which is humble, is by theme to provide our national judges and prosecutors with material that enables them not to ignore that human rights is the core also of international cooperation. The first one is an easy one, is on prison conditions, Aranias y Calderaro. So the structure of this little tool is first a short analysis of the case law, second information on how to obtain information, and that's important. Someone said that maybe if social rehabilitation departments could be involved, it would be easier. So where to, who to address with, and finally something that comes from me. I'm already old enough to be able to say very simple things, say what to do if this comes to your desk. And so the first one is on prison conditions. The second one is, it's going to be very difficult for us. It's on in absentia trials. Vanya knows very well why. And the third could be, well, to make them have an holistic approach on EAWs and several different instruments of the European Union that could somehow avoid a discrimination of a suspect that, because it's not the national of your country, doesn't have, in fact, the same rights. That's it.
Thank you so much, Joana. Thank you for your insights and so eloquently drawing out the key takeaways from each participant's input today. And for identifying a very concrete way forward, which I'm very excited to hear about on this holistic approach. I'd also like to thank each of the panelists, each of the moderators today for their contributions. We've identified plenty of obstacles, but also ways forward, I hope. And I'd also like to thank the participants for spending the afternoon with us on these very important topics. And just before closing, because we're just running out of time, to thank again our partners for their terrific work on this project, and the team here at Fair Trials. It's been a real team effort. So thank you to Ilse. Thank you as well to Isaline, one of her colleagues who can't be with us because she just gave birth to her little girl a couple of days ago. So that's a pretty good excuse not to be here. And she's done terrific work on this project as well. So I'd like also to thank her very much. And to our communications team for making it possible, even for me, to do something online. So thank you very much. And we will be following up with our full report in the coming weeks. We'll send it to you all, everyone who signed up, by email. And we very much look forward to continuing this discussion. So thank you very much and have a good rest of the day. Thank you. Bye.